Good evening, everyone. Welcome to the 2024 Judge Frank M. Coffin Lecture on Law and Public Service. My name is Lee Ingalls Softly. My pronouns are she and hers. And as the President and Dean of the University of Maine School of Law, it is my honor to welcome everyone to this annual lecture. As we begin the evening, we acknowledge that the land and water that surrounds us are a part of the Dawn Land. These lands were the homelands of the Wabanaki nations, the Penobscots, Passamaquoddy, Micmac, Maliseets, Abenaki, and other Wabanaki tribes. They were the ancestral fishing, hunting, and agricultural grounds inhabited by the Abenaki and Wabanaki people for thousands of years. I am delighted to see former and current law students from Maine Law here tonight. The Maine Law community is an extraordinary group, and as an official branch of the Maine Law community, I would like to extend a warm welcome to the members of the Coffin family and to the Coffin clerks who are here with us this evening. I think we call them the Coffin Clever. So I have promised that I would not make my friends in the Coffin family stand up, but if you would wave so people can see you and say hello. Thank you very much. And if you were a member of the Coffin Clever, would you wave? This is good. Very good. I also want to welcome distinguished members of the Maine and Federal Bench and Bar who are joining us here or from afar. And I won't even try to introduce you to most of those dignitaries who are here because I'll miss someone and then I will get emails for the next 6 months. But I do want to introduce my original mentor, former Attorney General James E. Tierney, who is here with Pulitzer Prize winning author Liz Strout. And I'm going to ask them, all you have to do is wave. There you are. Thank you. I will not tell you all the secrets and all of the mentoring that Jim did when I began this job because I want to keep the job for just a month or two longer. I also want to take a moment to thank our amazing staff at Maine Law who helped bring this lecture together in a very hectic time at Maine Law. So let me thank Justine Satterthwaite, my amazing administrative assistant in the gold at the back. Rob Pareca, our ever-patient advancement and events coordinator, hiding in the back. As always, Barbara Riegelhoff, who has been so helpful and so supportive as we have made arrangements every year. Where are you, Barbara? Wave. Thank you. And of course, I want to thank our speaker. Oh, wait, before we get to the speaker, where are you, Nicole Vinyl? Are you here? She had to leave. Make a note of that for her HR record, and we'll move on. Now I will thank our speaker, Dennis Parker, for leaving a very intense role at the National Center for Law and Economic Justice to fly up the rainy East Coast to be with us today. You'll hear a little bit about the fact that he was shanghaied into talking to students in a conversation regarding Brown versus the Board of Education, and the students are still in awe. This year marks our 31st annual Coffin Lecture, which speaks volumes about the legacy of our very much missed friend and colleague, Judge Frank Coffin, who departed this earth in 2009. In these complicated human times, those of us who had the privilege to know him miss the judge's wisdom and deeply thoughtful conversations very much. Judge Coffin was a role model and amazing friend. He was a true Renaissance man. He was an artist, an author, and an extraordinary jurist. His career included work as a private practitioner, service as a United States congressman, and his highly respected time as a judge of the First Circuit Court of Appeals. And through it all, he wrote and spoke prolifically about the importance of public service, and he was an unflagging champion of legal services for the poor. As we celebrate the judge's legacy with this annual event, I want to take a moment to reflect on the name he allowed us to give this lecture. We're all here for the Judge Frank M. Coffin Lecture on Law and Public Service. The judge's focus on public service bears emphasis today. The work of our citizens in so many areas of public service has been and will be critical to the health and future of our democracy. Engagement in public service provides all of us with an opportunity to reflect on our own individual and collective commitment to doing justice in our society, which is founded on the rule of law and access to justice. And I urge each of you to think about how you can incorporate Judge Coffin's commitment to public service into whatever career and life path you choose. Judge Coffin was a staunch supporter of Maine law, and more than that, he encouraged young lawyers and professionals to pursue careers aimed at lifelong service to the public. Publicly and privately, he challenged all of us to pursue justice in whatever sphere of influence we might have, from grassroots projects to expansive institutional innovations. In keeping with Judge Coffin's exhortations, it's my privilege and honor to announce that tonight's lecture will be delivered by Dennis Parker, the Executive Director of the National Center for Law and Economic Justice. Director Parker's topic tonight will be Brown versus the Board of Education. How far have we come? How far do we have to go? And here to introduce Attorney Parker is Maine Law's own Professor Caitlin Ainsworth Caruso. Professor Caruso, who is teaching civil rights litigation this semester, invited Attorney Parker to her class this morning, and we are incredibly grateful that he took the time to meet with our students and discuss the Brown decision. And before I turn the podium over to the good professor, let me tell you how fortunate Maine Law is to have her extraordinary teaching and writing skills. Professor Caruso grew up in Maine, but wandered away to receive her BA from Northwestern, where she graduated magna cum laude and earned her Phi Beta Kappa key. She then received her JD at Yale, serving on the Yale Law and Policy Review as the notes editor, and was the student director and then, after graduation, the clinical fellow for the San Francisco Affirmative Litigation Project. In her decade-long career in legal practice, she served as Judge William Kayada's first law clerk, clerked for the Honorable Harry Leinenweber, and she has lectured widely and written prolifically, all of which earned her a reputation as a legal writer and speaker of excellence. I am delighted to report that in 2021, we lured her back to Maine as a visiting professor, and she is now officially a tenure-track associate professor at Maine Law, where she has received some of the highest accolades from students that I have ever seen. She's also been an extraordinary help to me as Maine Law's dean. She is one of the people who steps up whenever I need help, and I start my conversations with, "Here's your answer. Yes, Lee, whatever you need, Lee." And Professor Caruso responds exactly correctly every time. I could not be more pleased that she has chosen to launch her teaching career here in Maine. And so, to introduce Director Dennis Parker, I give you Professor Caitlin Ainsworth Caruso.
Thank you, Dean. I promise this is not an endless series of introductions. I will momentarily introduce our speaker for the evening. But first, I do want to take a moment to thank Dean Softly, to thank the Coffin family, to thank the Coffin Clever, near and far, and for all of you for allowing me to speak briefly tonight. I feel incredibly privileged to get to introduce the Judge Frank M. Coffin Lecture on Law and Public Service. I will not attempt to rival the introductions that he used to give to these lectures. He was and remains a legend, and I would not dare. But as a child of Maine lawyers, and as somebody who had the great good fortune to clerk for one of the many notable members of the Coffin Clever, hi, Judge, I have heard stories about Judge Coffin for most of my life, and in particular about his extraordinary talents, not just for judging, but for justice, for art, for humor, for mentorship, for writing. His wit, I am reliably informed, was matched only by his warmth and his love for Ruth and their children. So I am also among those who are indebted to him for his years of attention and service to the law school, and in particular, for the clarity of his vision that Maine law must remain a core part of the positive force of the Maine legal community. I am honored to be here while Maine law works to further that vision and to instill in our students the centrality of justice and public service in every role that they undertake. And in that, it is difficult to think of a better role model because it is difficult to think of a public service position that Judge Coffin didn't have at some point during his remarkable career. Maine law remains firmly rooted in the determination to train and support students who come to us seeking the tools to further their own view of social justice and the public interest. In fact, that commitment continues to grow. Quite selfishly, I am grateful to report that I recently had the chance to take up leadership of 2 programs at the law school, each started by a titan of the law school community. The Certificate in Public Interest Law and Social Justice and the law school's Economic Justice Fellowship. The Certificate in Public Interest and Social Justice was founded by the incomparable Professor Emerita, Deirdre Smith. I will never get over having to call her Emerita, along with my wonderful colleagues in the clinic and incredible partner in Crystal Williams. The certificate not only allows our students to demonstrate publicly their commitment to public interest writ broadly, but it also delivers them with the diverse skills and perspectives that they need to engage well in this kind of work. The Economic Justice Fellowship, founded by Professor Emeritus and former Dean Peter Pittigoff, who I also have not accepted has retired, is awarded to an incoming law student, an incoming 1L each year. It goes to someone who, like Peter, is especially committed to building an economy in which every person can live a dignified life. I see both of those programs as part of the law school's commitment to helping our students prepare and engage in holistic advocacy. We have to empower our students and graduates to go out into the world and use all of the tools like litigation and policy advocacy and community partnerships to combat the circumstances of deprivation and systems of oppression wherever they find them. So, with that history and gratitude firmly in hand, allow me to finally introduce our speaker for this evening. In his career, he has used all of these tools and more to fight injustice, discrimination, and inequity. Dennis Parker is the Executive Director of the National Center for Law and Economic Justice. NCLEJ uses litigation, policy advocacy, and its connections to grassroots organizations to improve non-discriminatory access to essentials like housing, healthcare, public benefits, food, employment. It deals in state law and federal law wherever there is an opportunity for progress and a need for a push forward. Before that, Dennis headed the Racial Justice Program at the ACLU and the Civil Rights Bureau for the New York Attorney General's Office. He spent some of his early years of his career doing criminal defense for the Legal Aid Society. And as if that weren't enough for an entire lifetime, he spent well over a decade directing the educational work of the NAACP Legal Defense Fund. He did that through the 1990s, which is an era in which doing that kind of litigation was already tough and growing ever tougher. He is, in short, a lawyer who is just incredibly expert at combating marginalization and oppression, especially when it is directed at our school-age children and the people who love them. He is also a teacher. He teaches courses on education law both at NYU Law School and at Columbia Teachers College. And let me tell you, what a teacher. As Dean Softly mentioned, he joined my civil rights litigation class this morning, and my students had a chance to meet with him and discuss some of the issues that you're going to hear more about tonight. Brown versus Board, its legacy, the contemporary picture of desegregation litigation. He was candid and generous with my students in ways that only gifted educators are. He laid out the strategy and the complexity and the wins and the heartbreak of decades of a career well spent. You are in for a treat and a privilege. With that, please welcome the extraordinary Dennis D. Parker.
Thank you so much, Professor Caruso. Your discussion of the importance of public interest law is so impressive. I'm just tempted to stand up and say what she said and sit down. And thank you for inviting me to the class. That's very important to me. These are times, as you know, that are very troubling, and there's so many challenges that we are facing in terms of equality and access to justice. And so in the times when you start to get a little cynical and start to worry about what's going to be happening next, to go and sit in a classroom filled with these extraordinary, bright, and committed students gives you hope. And it gives you hope to see a professor so gifted. And so, Dean Softly, congratulations on your faculty. Thank you for this invitation, and thank you all for coming tonight. It is a real honor to be in this beautiful space, particularly speaking at a lecture that's honoring a person who exemplified public service in government and private practice, and who so valued the role of law in protecting the rights of the most vulnerable. And that honor is only amplified by the fact that the lecture is held at a law school that places such a premium on public service. One of the first things that I did in preparing for this is to go to the website and look at the activities that are available to students. And I contrast it with my experience in law school now 44 years ago, where the things that were available, the clinics, the professors who urged you to do public interest law were limited. And to see all of the availability now is exciting for me and really does give me hope for the future. Programs like the Cumberland Legal Aid Program, the Refugee and Human Rights Clinic, the Maine Association for Public Interest Law, Center for Youth and Policy, the certificates that that Professor Caruso talked about, are so impressive. Of course, as you've heard, the danger of naming specific organizations is frightening because you will inevitably leave out some. And I'm embarrassed not to have included more of the public interest organizations here at Maine Law School. But I'm also pleased, and I'm pleased that there are so many opportunities for students here that it would be really impractical for me to list them all within the constraints of the time period of this lecture. But the work of each of those organizations, classes are so vital and so important for the work that needs to be done in the public. I thought I'd spend some time with you tonight reflecting on my career in public service. And let me start by saying that there are so few things in life that you can talk about where you can say that you have either few or no regrets. And my career is something about which I have few or no regrets. You'll notice I heard last week that you're allowed to use prepositions at the end of sentences, but I am very old-fashioned, so you'll hear my tortured construction as I try to keep them in the middle. But that career has been important to me. My choice of the career, the organizations which I've had the honor to work at, represent a life choice that's been particularly pleasing to me. And I'll discuss it at greater length later, but there still are a number of nagging, sometimes difficult questions that I find myself asking increasingly as I grow older about public interest law practice. But first, the good things. And those tend to fall into two categories. The first are the things upon which you work, my construction, and the second is the people with whom you work. The work, particularly now, is often extremely challenging. But to me, it's a rare opportunity to engage in a career which allows you to further your most deeply held beliefs. I've experienced many times joy and also disappointment and pain in the course of that work. But I've never regretted it. I've never felt that I've wasted my time, and I never wished that I had done something else. And then there's the people. And one of the greatest pleasures for me has been the opportunity to work with the colleagues that I've worked with over the past 44 years. So many brilliant and dedicated lawyers and non-lawyers. So many people who now are on the bench or head or work in social justice organizations nationwide, who serve in important positions in federal or state agencies, or who teach in law schools throughout the country. And I am particularly honored that some of those people are here with us this evening. And again, my apologies for everyone whom I've admitted. And I should point out that I am pleased that 4 of my high school classmates are here today, and it's very exciting to see them again. But my colleague, Leah Lotto, who works at NCLEJ and has a long history of working tirelessly to fight for the rights of low-wage workers and agricultural workers, and those people who we depend on to eat and who we treat very poorly sometimes. And Leah who is a resident of Portland. She works remotely because she's too lazy to commute down to New York City. And she works hard to fight for the fairness of agricultural workers and home health care attendants and restaurant workers and all of those people, those essential workers who we deemed essential and then treat poorly. Zach Hayden, who's chief counsel of the ACLU of Maine, and his colleagues from that wonderful office. And Zach is someone who I had the pleasure of working with when I was back at the ACLU, and so excited about the work that he's doing here in Maine. And then Jim Tierney, who, as you heard, is the former Attorney General of the state of Maine, and now a law professor. And Jim not only vigorously represented the people of Maine in his job as Attorney General, but he also led efforts to convince attorneys general across the country to further social justice goals. And he also reached out to people in positions that were for social justice organizations and suggested that if they didn't think about the possibility of employing or of using these attorneys general as colleagues and as potential helpers in their work, they were missing an opportunity. And it's wonderful seeing James again. I've had the pleasure of working with him for more than 20 years. And it's been wonderful working with folks like these, but it's also great to be a part of organizations with an extraordinarily rich history. And I've been, as you heard, employed by organizations that have played really significant roles in social justice in the United States. And for me, one of the premier organizations has been the NAACP Legal Defense Fund, which I first worked with as a law student and then was pleased and surprised when they hired me to come back working full time. And the interesting thing about LDF is it's much more polished now. When I was there, there was an old office and there were things just sort of laying around. So you would continually bump into history in ways that surprised you. And I remember one day I was working on a brief in the 11th Circuit and wanted to reread Brown. And so went to the library, and for the students here, there used to be things called libraries. And they had these things called books. And so I took down one of these books and started to do the research on Brown and was outraged that someone had underlined it and had written notes all over it. And I was like, what kind of person would go to the library of the organization and write on the reporter? And then I went to the front of the book and it said, from the library of Thurgood Marshall. And this was Thurgood Marshall's annotated copy of Brown versus Board of Education. It was like holding, a piece of the True Cross or something. It was just stunning. And there were constant reminders as you worked there of the history of the organization. One of them that haunted me was going through an old case file, and it was always exciting for me. Professor Caruso mentioned that I worked at LDF for about 14 or 15 years, and when I was there, I was in charge of the school desegregation litigation docket, which consisted of about 300 cases that were still pending throughout the United States. And very often you'd be assigned, there'd be an issue that came up in a case, and you would take it out and realize that no one had really looked at it before. But I always enjoyed looking at the procedural history of these cases, some of which had been filed before I was born. Literally worked on the Baton Rouge school desegregation case that was filed in 1954. And I love to look through its history and look at the lawyers who filed it, and they were people like Thurgood Marshall and Judge Carter and Constance Baker Motley, and just this incredible crew of amazing lawyers. And one of the things that I found in it was a newspaper article that had been cut out right after Brown was decided. And the article was an interview with Thurgood Marshall, and one of the things that then Director Counsel Marshall said was, this struggle, Brown, it was a hard struggle. And you have to realize that in the United States, discrimination is deeply entrenched. And so we won this, but we don't think that things will change immediately. And then he said, probably take 5 years before we've desegregated the schools. And I wondered about this because obviously there are a few people in the country who were more familiar with discrimination than was Thurgood Marshall. The stories that I've heard, including from some people who were his colleagues, of him being run out of town or being picked up by police officers and having his co-counsel follow that car because they were afraid he was going to be lynched. So to have that experience, my first secretary is someone who had worked for Justice Marshall and back then, because there were no computers, would travel with him to type up his papers. And she told me that it was like a running joke because you couldn't stay in a hotel, you had to stay in people's houses. And when they got to someone's house, there'd be an argument about who got the bedroom in the front of the house, and they were always trying to get someone else to get it because that's the one where the bomb could be tossed through the window, and that was a joke for them, but it was an indication of just what a dangerous job it was. So for him to say, having experienced all of this, that it will be 5 years, I wonder whether he just didn't want to give a clue that he knew that this was going to be a very long struggle, whether he was mistaken. But it just struck me, because of course, the fact is that 44 years later, I was still working on these same cases. And you'll recall, I don't want to go into detail, but the history of what happened after Brown was decided, and even the history of the second Brown 2 opinion, which, and I was telling your class today, it uses this amazing language about children and says that segregation injured children in a way that was so serious that it was unlikely ever to be undone. We hurt children in a way that they will never recover from. What an amazing finding. And yet, the next order was, and we're going to deal with it with all deliberate speed. And that was regarded as a signal by particularly these southern school districts to do nothing or to do things that prevented desegregation. And it's amazing, you read the history, Virginia, some of the counties closed public schools rather than desegregate. Every effort was made possible, rezoning, all sorts of things, or even if they permitted black students to attend white schools, their families would be subjected to threats of either violence or of being fired. And so really very little happened until the 60s, and it wasn't until the 60s that the court started to realize that we need to do something now, because this is getting kind of grotesque. The kids who were 5 are now 15, and we still haven't really done anything for them. And what was interesting is that, like Brown, which was a 9-0 opinion, and was 9-0 deliberately to send a message that we are serious about this. And at least for the early years, the most significant cases were all cases that were 9-0. And they sent this message that this has to be done. In the Green case, where they talked about eliminating the vestiges of discrimination from all of the schools and looked at all of these factors, including faculty and transportation and extracurricular activity, and the other 3 that I always forget. And in Swan versus Charlotte Mecklenburg, where they used, again, this extraordinary language and said, you've been messing around for too long. You have to desegregate now. And you could do it by drawing bizarre attendance zone lines in order to desegregate the schools. And you could even transport students, which of course later became known as busing. But in all of the time of these cases, the court made clear that the goal of the litigation was to eliminate the harm that had been done by segregation. And then that changed in the period around when, I'm not going to take the blame for it, but when I started doing education cases. And then suddenly the court's priority shifted to, we need to return authority back to the school districts. No mention of the damage that had been done to children. And slowly, the message that was being sent to school districts was, we want to get these cases dismissed. And so a lot of my career was, I once had a judge in Alabama put 15 cases on his docket and said, I'll proceed by order of show cause, and if you cannot demonstrate to us in 2 weeks why we should not dismiss these 15 cases, we're going to dismiss them. And we prevailed on him to give us more time and to recognize that there was more to be done rather than a default dismissal. But that came from signals that were being made by the Supreme Court. And so suddenly 9-0 became 5-4, where the 5 were talking about dismissing cases. I had told a story to the class today about the first time I saw a Supreme Court argument. Was in Dowell versus Oklahoma City. Oklahoma City was a city that had been under a desegregation order, had desegregated for a few years, and then went back to its own old system of student assignment, which exactly replicated the segregation that existed before the court orders. And the Supreme Court in that case said, well, true, it's segregated, and it's as segregated as it was, but that's not because of the old dual system. That's just because people tend to live where they want to live and want to be near people like themselves, and it's not a vestige of discrimination. And so what you had was this period, 10 years at tops, where the schools were desegregated, and it was stuck in between hundreds of years of segregation on both sides. And so that was the first case. And then there were cases that dealt with, how you dismissed them, and you could dismiss them piecemeal. And then the two big cases were the cases Milliken, which limited the ability to order a remedy across district lines, dealing with Detroit, where white students fled Detroit when a desegregation order was entered. The judge, realizing he could not desegregate the schools without reaching out to those suburban students, ordered that they be part of the plan, and the court said, no, that's exceeding your authority because you're not showing that the districts themselves segregated. And so you were left with a virtually 100% school district of children of color. So that was the first case which limited federal desegregation litigation. And the second one was the Rodriguez case, which held first that there was no federal right to an education in the Constitution. But then secondly, countenanced dramatic difference in spending for Texas school districts and refused to recognize poverty as a protected category in the way that race is. So these were difficult times, and those are times that we're still in. Gary Orfield, who was just retired from the Civil Rights Project at UCLA, writes extensively about segregation. And in many ways, segregation in the United States is worse than it was in the 1960s. And I often ask my class, where is segregation the highest in the country? And they are often surprised to hear that it is New York City. that is one of the most segregated school districts in the nation. My students, and I have two sets of students, one are law students from NYU Law School, and the other are educators from Teachers College. And they ask about whether I view these cases as successes. And they point at the resegregation of the schools. They point to the statistics that show the overall loss in black teachers and administrators between 1954 and now. They talk about the disproportionate burden that was felt by black students. You know, the harm of segregation was experienced most harshly by black students, and the remedies to address that were also felt most strongly by black students. White students generally refused to be bused to desegregate schools. And so people ask, was it worth it? And I think it was. I think it was necessary, but I think it was at an enormous cost. One of my introductions to Brown was when I was in law school, and Jim will know this. My law school classrooms had these paintings on the wall that were lawyers and judges from 400, 500 years, some of them with the wigs. And the one thing that virtually all of them at this time had in common were they were white men. And there was one exception, and there was a man, and it was an almost impressionistic painting, and he was sitting in what was obviously a Caribbean setting wearing a white suit. And I just thought, boy, and he was a black man, and I thought, that is one sharp individual. And then I later learned that he was Charles Hamilton Houston, someone who is not as well known as he should be. Charles Hamilton Houston was an extraordinary person and was instrumental in putting together the strategy for Brown. He went to Amherst, went to Harvard Law School, where I believe he got both a Bachelor of Law and a Doctor of Law degree. Was the first black student on the Law Review. Was a lieutenant in the First World War, and that experience changed Houston. He wrote, "The hate and scorn that was showered on the Negro officers by our fellow soldiers convinced me that there was no sense in my dying for a world ruled by them. I made up my mind that if I got through the war, I would study law and use my time fighting for men who could not strike back." And he later became the dean of the Howard Law School, where he set strict standards for what he expected of his mostly black law students. In the famous statement that a lawyer is either a social engineer or a parasite on society. That's one of my favorite. I'm not into tattoos, but if I were going to get one, that would be it. And in the book Simple Justice, which is a wonderful history of the litigation of Brown, they talked about how the strategy was created and how the purpose of it was not just, or was not really even primarily to desegregate schools. It was to end the policy of separate but equal that had been declared in Plessy versus Ferguson, and to do it strategically in a way that went over decades. In terms of choosing the types of cases you were doing, choosing where you did them, concentrating on higher education, because you knew in a lot of these states there were no particularly graduate programs that were available for black students. So a number of southern states would rather send you to Harvard at their expense than to permit you to go to the law school in that state. And they were able to finally persuade the court that this isn't separate but equal. You know, they live in that state. They should be allowed to go to law school or to whatever graduate school. And because they can't, you either have to build them a school that is as good, or you need to desegregate the school. And they knew that once they realized that black and white students can sit together and not die, that would make it harder to maintain segregation in the K through 12 level. But the treatment of those students was awful, who made it into those graduate schools. Students who were literally cordoned off from the rest of the class, who went through 3 years of law school and didn't speak to a single other student. Imagine that experience. So there was a cost, again. Now, one of the interesting things about lawyers and public interest lawyers, and this is true of me, I thought I was going to get out of law school and I was going to change the world. Everything would be great. I had my law degree and I was going to bring the cases that were going to get rid of injustice, and we'd all be sitting around together. And spoiler alert, that did not happen. But part of it was that my sense of what a lawyer did was that we were the leaders, that we were the ones who would make these decisions and bring these cases. And so there was a certain arrogance in us who got out of law school in 1980 and before, that we were the ones who were going to be the saviors. And when they talked about segregation, for instance, it would always be described as the legal strategy to end segregation. Less notice of the fact that there were other things going on, that there were people having bus boycotts, and there were people who were protesting these conditions in the street, and that frequently these things were happening well before the lawyers were involved. And in fact, if you look at history, sadly, lawyers are not at the vanguard of social justice. They're bringing up the lead or the rear, saying, we're leading from behind. And so I'll come back to that later. But finding that article by Justice Marshall, and then also questions, I love teaching because you learn so much from the students. I met one, actually she wasn't a student, she was a former paralegal of mine who then did graduate work in education, and we had lunch actually just last week, and she was talking about the problem that she had with lawyers. And she said when she was getting her doctorate at NYU, she served as an advisor to a clinic that dealt with students who were being disciplined. And she said she would talk to the students and they would tell her, usually the issue was whether a student would be suspended or expelled. And they'd have the hearing, and then the law student would come in and say, "We won!" And then she'd say, "What did you win? What changed as a result of the fact that you were keeping that student in the school, but not changing the underlying circumstances that led to his being disciplined? What steps are you taking to end these things?" And then last week, I got this extraordinary question from one of my students who was referring to an article about what you should do to help disadvantaged children in education, what programs you should give them. And she says, many well-meaning proposals for educational intervention seem to be built on the premise that the results of an excellent education for all are possible if we act directly on the lives of at-risk students and push them through education out of difficult circumstances. But it asks no critical questions of the very structure that arguably requires inequality in education. And she goes on to say that the interconnected nature of those who fail or are uneducated and those who succeed are educated, and their existence in one landscape is not called out, nor is the difficulty of imagining the contradicting image of equal distribution of educational opportunity under a systemic, unequal distribution of wealth. And the one thing my students always comment is because of the funding formula that are used almost universally in the United States, there are winners and losers, and that follows them for their life. Add into that the environmental damages that they suffer, the health differences, the access to nutrition, all of these things cripple the children at a young age. And so the answer is a complicated one, and it's one that we have to work on addressing in a more comprehensive way. I had two cases of which I am most proud, and interesting, one was a case which we won, and the other one was one that we lost. I'll have to move quickly because we're running out of time. And both of them, for me, raise questions about the efficacy of litigation as a tool of social change. The first was a case called Sheff v. O'Neill, and it is a case that was brought by a number of national organizations who wanted to get around the Milliken and the Rodriguez decisions in the federal court. And there was a decision that we can't do desegregation in the federal court anymore because of the limitations of that case. But Connecticut promised, the Connecticut Constitution did provide some promise of things that you could do. And that case was brought in 1989, and today I answered an email where we were talking about how are we going to get a remedy in this case that we won in 1995. And the case continues. The end result was mixed. We won the case. We got a declaration that segregation in Connecticut schools violates the Connecticut Constitution regardless of whether or not it is intentional. I worry about how long that will stand, but at least for now, that's the law in Connecticut, and you have to address what is called de facto segregation, even if it's not the result of state action. Because we knew that we didn't ask for a remedy in the complaint. And when we won, I guess we were a little surprised, and it's sort of like the dog that catches the bus. You know, now what do we do with this? And we realized that forcing students to move on 24 school districts in the area surrounding Hartford would be difficult. Now, the interesting thing about Connecticut is it is one of the wealthiest states in the United States, but it has three of the poorest cities, Hartford, New Haven, and Bridgeport. And the proximity of extreme wealth, you know, Greenwich wealth, and extreme poverty, Bridgeport, is striking. And so that's why the case was brought. So we realized that it would be difficult to get the state to go along. I would just add resistance to desegregation was as harsh in Connecticut as it was in any of my southern cases. I remember turning on the radio and hearing a This American Life, and there was a black student in Hartford who wanted to see, because there was a transfer program that I'll describe quickly, but she wanted to see if she could attend a suburban school district, and she went to a school board meeting, and this black child from Hartford had to listen to parents one after another saying, we don't want those criminals coming into our schools. They'll pull down our test scores, they'll be violent, they will destroy the property. And so that question of stigma, you know, imagine being a middle school student and hearing that people who look like you are criminals, are stupid, are violent. You know, all of those things. So stigma takes many forms. But the good thing about Sheff was that we got 42 magnet schools, and we got a program that allows thousands of students to leave Hartford and go to the suburbs. In spite of that, there are still massive waiting lists for both of those programs. And the reasons are complicated, and I could talk about it later. But the bottom line is that there are still the majority of black and brown students in Hartford are attending schools that are overwhelmingly children of color. And they can't get into the situation that they were promised by the lawsuit. Again, positive things. They created the high-quality magnet schools. They encouraged the state to think regionally. They gave opportunities for the suburban kids. If you had a kid who wanted to do performing arts, he could get a better deal at the magnet school for performing arts in Hartford than in their suburb. And so there were opportunities that went both ways, but they were never described that way. But again, those waiting lists persist. The other case, and I'm trying to see how quickly I can get through this, was a case that I brought at the ACLU. It was called Atkins versus Morgan Stanley. And it was a case that we brought that was designed to address the economic and racial impact of the process of mortgage securitization, and particularly as it was practiced by financial institutions in the beginning of this century. And the result of these practices is they left black and brown homeowners with toxic mortgages which were designed to contain features which virtually assured that these mortgages would fail. And then when the economic crisis hit in 2008, sure enough, those clients, and we had 4,000 black homeowners in Detroit, and these were homeowners who were following the instructions that they had been given, that to get into the middle class, to get your kids into better school, to get them in safer neighborhoods, you should be a homeowner. And they ended up in mortgages that no one could continue paying. And they would sometimes exhaust all of their resources to keep up with the balloon mortgages and to pay the prepayment penalties, and still find that they couldn't keep up with it and then would be evicted. And what struck us was that, and I guess, well, the case ended in a dismissal for procedural reasons, having to do with largely the inability to get a class action certification, but also some things were time barred, and so we lost. Now there were positive things, and why would I say this is a case that I'm proud of? When it first, because it made good law, it held in an early hearing that mortgage securitization was covered by Title VIII, the Fair Housing Act. And secondly, it addressed a problem that we saw, which was the framing of the economic crash of 2008. Because then it was described as these greedy black and brown people are taking mortgages that they couldn't possibly keep up with, and they're just dragging the economy down. They destroyed the economy. And these are said by institutions that were exploiting these people, and then were getting propped up by the federal government because they were too big to fail. But the clients were not too small to evict. And they did evict them. But we wanted to show what was going on, and so we used that as a way of framing this discussion, of saying, look at who the culprits are in this. And, whether it changed anything long-term, I'm not sure, but it was important to get that out there. The third aspect, which is a bittersweet one, and I described it in the class today, is we called our clients to tell them the case was dismissed. My co-counsel and I were virtually in tears to have to tell them that they were SOL, as they say. And they were calm. And they said, thank you for representing us. They said, we're glad that you were there. We were glad that we got to tell our story. And then they said something which has continued to haunt me since then. And this is the bitter part. They said, you know, we appreciate everything you did, but we never thought we had a chance. We never thought we could beat Morgan Stanley and Goldman Sachs and these institutions. We never thought that poor black homeowners could prevail. Now, I think that we could have prevailed had there been, well, it's complicated, but I think we could have won. But the fact is, you could not turn to those people and say, that's ridiculous. This is the American justice system. Of course you could have won against Morgan Stanley, who had 40 lawyers trying to make sure you get kicked out of your house when you have 3 or 4 lawyers on your side. Of course you could have won. And that issue about the difference between law and justice is one that I've been struggling with. So how do I tell my students you could achieve meaningful results in social justice when you have these existing systemic inequalities? And it's difficult, but I just want to make sure that I don't leave with the impression that I in any way are saying that it's futile to do this work. I think it's necessary, I think it's admirable, I applaud you for it, and it makes a difference. It's easy to lose sight of the progress that has been gained in so many areas as a result of litigation, and the list is long, whether it's gender and sexual equality, voting rights, employment, environmental justice, disability rights, so many areas where American society has changed fundamentally. I often tell the story of being with my mother when Obama was elected for the first time, and she grew up in South Carolina, very poor, worked as a maid for most of her life, and we were watching the returns, and she said, he cannot win. He is a black man, he cannot win. And I called her the next day after the results were out, and it was as if, you know, cats were flying, and she could not deal with that world. And that's progress, and it's meaningful progress. It's progress that came at a huge cost, but it counts for something. And the truth is, the path to progress has never been linear. We've gone through, you look at post-Reconstruction, you look at so many eras, we go up and we go down, but we keep moving forward because that's what we do. And some of that depends on using litigation as a tool of social change and using it in a way that's intelligent and strategic. And that means abandoning my arrogance as a law student and saying I have the answer, and recognizing that you need to work with people who are affected by the cases that you're bringing. You need to let them decide what it is they want. You need to help them find a way to get what they need, not what you think that they need. And you need to think of things like not just what lawsuits to bring, but where do you bring them? And how do you bring them? How do you work with legislators? You could use litigation as a spur for change. I had white superintendents in southern school districts take me aside after I was deposing them saying, we want you to win because the things you're asking for will be better educationally for our children. But if I said that, I would be fired in a minute. And so sometimes people will recognize that what you do, that you want to do, is also the right thing. And so we do need to put people who are most affected at the center of our efforts to affect social justice, and recognize our role. I was pleased today, there have been a number of times that references were made in Professor Caruso's class, but also in speaking to other people about something that's very important to me, and that is a letter that was written by William Quigley, who is a law professor in Louisiana. And he wrote a letter called Letter to a Law Student Interested in Social Justice. And I'm pleased to see it because I assign it for my classes, but I also read it every year, and particularly when I'm feeling, a little bit down about how things are going. And I read it because it is a source of inspiration. And at the beginning, it seems really discouraging. He says, if you look at law, if you look at the way law is taught in law schools, and the way that it's practiced in the courts, what you are doing runs counter to that. You are swimming upstream, and you are swimming upstream because of a number of things, including the allure of high salaries, which, as my colleagues can tell you, we are not getting. And so you're constantly swimming against the tide. And he points out that people in positions of power in all three branches of government, the ones who create the policies and pass and enforce laws, are from the group of people who are the most powerful. There are very, very, very few extremely poor people in Congress or on the bench or in other decision-making, not without exception, but it's still not what most people do. But then Quigley does a turn and he says, you need to continue your work with persistence and humility, and remember that all of the advances that had been made in the area of social justice were made by people who were told that the things that they were fighting for were impossible. And they were told that, and they keep doing it. And they not only didn't allow themselves to be deterred, but they permitted themselves to dream. And they dreamed those changes into existence through the hard work that they did. Professor Quigley ends by language which always gets me. And he ends by invoking something that's not often heard in law school classrooms, or I will allow the judges to correct me if I'm wrong. But he talks about love. He talks about love as a real motivating force. And he talks about people who face adversity in doing this social justice work and how they respond. And you could respond with anger, and you could respond with resistance. But he says, a response of love is the most difficult, but it is truly the only way that injustice and evil can be transformed. Love ends up at the center of social justice advocacy. Love in action, not the dreamy-eyed, soft music television commercials, but the love of a mother for her less able child, the love of a sister who will donate her kidney to save her brother, the love of people who will band together to try to make a better world for their families. These are examples of real love. This is the love that will overcome evil and put justice in its place. And so, like Professor Quigley, I look forward to joining you in this struggle and in the love and the ways that you work in the future to bring about, finally, justice and equality. Thank you.
So we have a few minutes left for questions. You're going to find a microphone right over here. If you have a question, step right up, and I'm sure you're going to get all the answers to all the questions in the universe in the next 10 minutes. For a price.
You mentioned Oklahoma City as a particularly sort of holdout of segregation and reactionary thought and practice, and it brought to mind for me the recent death of Nex Benedict, an out non-binary student, also in Oklahoma, which came as a shock to many of us in the trans and broader queer community, and also came, one would submit, not coincidentally, shortly after the appointment of Libs of TikTok member, founder Chaya Raichik to one of the state commissions on education by the noted culture warrior and State Superintendent of Education, Ryan Walters. And I'm just curious, what are your thoughts about the role of impact litigation in trying to push back against the moral panic around the presence of queer youth in the educational space today?
Yeah, I think that issue, along with so many other issues, I mean, they're related. You know, if you look at the books that are being banned in Florida, they are books about Black history, but they're also books about gay and queer subjects. And so what is happening is there is an effort, and maybe this sounds conspiratorial, but to bury that history, to bury the existence of people who are gay, people of color. And I think that, you know, I know that there are cases that are being filed, and it's important. But the other important thing is to recognize, I was speaking to someone who had talked about how they work locally. And these are things that are really important to work at the local level, to make sure, and there were some positive results in school board elections. And that makes a huge difference for the experience of the students who you describe, as well as students of color, English language learners, students who are undocumented. You know, I expect that there will be a case in the very near future that will try to overturn Plyler versus Doe, which is the case that says that you have to educate children regardless of their immigration status. I think all of those things are under attack. And I think, for me, I was telling the class today, you know, that it's fun for me to try to explain to my educators legal concepts. And so one of them is, I was telling them what stare decisis was, and they just looked at me skeptically and said, "Is that still in effect?" And it's like, and I guess that's one of the bitter lessons that I've learned. I was impressed at how quickly marriage equality happened. I expected it would take longer, particularly since it was not that long before the Obergefell decision that the Supreme Court had upheld sodomy laws. And so I wasn't prepared for that change to happen that quickly. I am not confident that that will stand forever. And I think the most bitter but necessary lesson that impact litigators, as well as people who do individual cases, is that it doesn't work that you win a case and then you move on to the next one. You're always looking over your shoulder. And I think litigation is a part of it. I think public education is part of it. You know, it's interesting, there's a book by David Cole, who is the legal director of the national ACLU, who talks about social justice movements. And his theory is that the movements are actually more important than the litigation. And one of the examples that he gives is how much, you know, when Vermont first had the acceptance of not marriages, but of unions, what they did was to do a massive public education campaign. And the purpose of the campaign was saying, these are people just like you who love someone and want to live with them. And it turned out to be successful in combination with litigation. But we do have to think strategically. Impact litigation will be a part of it, but it won't be the whole thing.
For sure. Yeah, you mentioned Plyler v. Doe. It's worth recalling that it was, I believe it was a matter of a day or two after the release of the Dobbs decision overturning Roe that the Texas Attorney General, Paxton, explicitly said, "This is our next goal. This is how we're going to determine that stare decisis is no more. We're going to challenge Plyler."
Mm-hmm. Yeah, it's like amazing. There was a character called Snidely Whiplash, who was a villain in some cartoon in the 60s. And you know, so much of what, you know, it's like, yes, let's take education away from children who are fleeing horrible places, and let's split up families, and it's almost a caricature. But, you know, we need to respond, and not respond in kind, but respond in a way that helps us build a society more like the one that we want.
Thank you so much.
Mm-hmm.
Other questions? I can cold call.
So, I'm Suzanne Crowell and just a member of the public, came with a friend. When I was working in fair housing at HUD, I was actually in a meeting with the Justice Department, people that were working on fair housing issues, and the topic came up about when banks or mortgage companies were targeting Black people to offer them, better, quote, unquote, mortgage terms and things like that, well, whether that actually constituted discrimination. And of course, the Justice Department, and this was during the Clinton administration, concluded that no, it just didn't. They couldn't see a way of making the case. So I have a feeling that relates to the Morgan Stanley work that you did, and I wondered if you could explain a little more about it.
Yeah, it does. And I think one of the reasons that they targeted these populations is because they were the ones who were least likely to have mortgages. I mean, in the early 2000s, what had happened is that these institutions had essentially securitized every mortgage in the country and sold them at a profit. And so what happened is they were instructed, my brother worked for a bank in Buffalo, and they did everything short of driving sound trucks down the street saying, sign here and we'll give you a mortgage. And it was always described as wanting to encourage home ownership, but the idea was, we want something we could securitize and sell. Because it didn't hurt them, by the time it was sold, they no longer had it.
Yeah.
It was also hard, and this is when you talk about structure. I was telling Professor Caruso that I was once sued by the federal government, by the Office of the Comptroller of the Currency, as well as the national banks, for merely asking for mortgage information from banks, because the information was clear that Black borrowers received rates that were higher, mortgages that had more toxic features. But it was difficult to prove because the Home Mortgage Disclosure Act had been written in a way that didn't require them to keep the information about individual borrowers. So you couldn't say, this person applied for a mortgage and he was, a Black lawyer and he was given a subprime mortgage, because you didn't have that information. And that was built into the law, and it was not built into the law by accident. It was not built into the law by accident. But it's difficult to prove, and we sued Morgan Stanley, but actually Morgan Stanley didn't do it. They worked with these other mortgage lenders who they instructed, go out, get these crappy mortgages, we'll buy them from you, and then securitize them. But there were these layers. One of the problems that we had was causation. When they said, you represent 4,000 people, can you demonstrate that their mortgages were bought by Morgan Stanley? And if you know about securitization,
No.
it's like, what did you put into the blender, And
Yeah, I read once that it was described as making sausage. Some of the sausage was bad, and you just put it into with the rest of it and sold it.
Yep.
But so they would say it's proprietary information, the information about
They
the
didn't have it.
individual.
It wasn't kept.
Oh.
And it was so complicated. I mean, it was, I sort of learned what it is to be a public interest lawyer, and it still amuses me to this day. We did discovery, and I got this angry call from the partner at the firm that will remain nameless, and he said, you're doing this discovery, I have to hire 40 lawyers to put this stuff together. And all I heard was, I have to hire 40 lawyers. And they already had a team of 12, and we had like 4. And it's like, aw. But that's what we were up against. And they dumped tens of millions of documents on us. And you know, I hate to say this, they overwhelmed the ACLU, one of the wealthiest public interest organizations in the country. We couldn't handle it. We couldn't handle it. And, you know, I know and I'm friends with some of the opposing counsel, and they're not evil, or they don't seem to be evil people. But these companies did something that was evil.
Yeah.
You know, I hate to throw that word around, but there's sometimes when it describes it.
I will, if I may jump in to add,
Yes.
and to underscore a point that you made, which is that the relationship went backwards with the securitizers, in the sense that it wasn't that banks were going out, finding individual people, offering them mortgages, and then securitizing whatever it was they had. The litigation after the meltdown showed pretty convincing evidence that they were taking orders from the securitizers, saying, we would like a mortgage that fits this interest rate, this, you know, size, demographically, and the banks knew who they would go and make those offers to. They were deliberately targeting not just communities as a whole, but very particular properties and mortgages and mortgage types and individual mortgages. And so it is, they behaved at that level and then lost the data.
And I mean, and when you think about it, I don't know how many of you have bought houses, and how many people have watched that stack of papers and had no idea what the hell was in that. But you can imagine being a poor person who was being told, don't worry, you know, you'll always be able to pay it. And we had one client who, you know, what they would do is they just refinance continually, and get people to refinance and then add. You know, there'd be a balloon payment and all these other things. And there was one woman who they said, you should refinance this week. And she did, and then they added a prepayment penalty that would have not been eligible a week later. So it was an intentional act of someone who they knew was poor. It's cold.
And on that uplifting note, I think we're at time. If you will all join me in saying thank
That
you.
incredibly cheerful note. Thank you all for coming. Dennis, thank you for this evening. It's been absolutely. Thank you all. Be safe.